specialist adwuma me ye en kan na me pega de a na me nsakra antimi pega na say me ma de so na love sisi say if you say me share Dawood 360 capsules and Dawood ointment abo me bebre dry you so maintain ya maintain bia obia mo modern so betimi apɛ Dawood ointment and Dawood 360 capsules enya bia to
odofo se wate bi adroya me ka ho asɛm no ɛno ho adanse ɛne wɔno madi no ko pharmacy ɛbɛn wo heba shop ɛbɛn wo ne koto Dawood ointment Dawood 360 capsules na sɛ de nkrofo di ho adanse no wo so bedi ho adanse wo pɛ sɛ wo frɛ ya ɛno na wo screen ase no 0244 886437 na 020 168 1717
Inro anya mapemfo abatan a woma woma nufo ani obi a onya mfihia dumienu FDA agidwadie nkratoe yi atum
Say kind, so what Nioma every useless enterprise. Oh no, would the biara da every say. Omonioma your papa, net senso, and to a beer water generator set, water pumps, mowers, Cummins, Kama, Lester Peter, Kiloska, and then Nioma would drop every useless enterprise biano. And just say, Onoakasakas won't pay you, and that's what the useless enterprise. At Nioma to say, Perkins, Caterpillar, Honda Gensets, a fay or plant a cassia and in Kuma, hotels, guest house, schools, restaurants, and now said you may put beer. Able to hear you so. Our 500 watt solar generator. I soundproof. Now how enter full beer. Nasawato gensets. Our 1 month chain. What the brown also installed the mouth free of charge. Yeah, won't you capre? And Major Sam say, so only Kania I will fee and I some poor Jumua. The only so better solar panel. Every useless enterprise. And more someone. And a friend now quite dear. And one last option. Joshua Kwai awo Adrigam Bridge near 69 American House at Champo Junction Bawalashi Newtown Junction Ashaliboche Social Welfare Medina and Afewokwa Denton Swa our Ridge Junction telephone 0203 005498 and 0248 169258
Wakaba at the Spine Therapeutic Center ahano ye share echinkasei eye wechi dompe osisi ye wo ya o kotodwe wo ya ukon ye wo ya otifie wo ye den to anamo na bra na ye nhwe wechi nkasei ni ma ahawo ba ebedi kan etwa scan no na be kire yen bebi a wo problem ni wo afi ye scan ni wi a na ya wo physical examination say even though your trust can no so no ebedomo soko ahwehwe wo nipadua no ba bia chia ba bia atene na ya tene ba bia ama we any the latest scan na ye bitwa wachi no se me the scan no esi wachi say ya na computer no peke C7 sa na che be bia yen sanfa ensi test complete. Sesia no, your trust can no one achi ewie. Screen no actually say abrante we no ne kunwachi no problem go ho. Eba ne chi ankasa so problem ho na ne sisi no so problem e wo ho. Enti say cheyen dompe ku a achi ase na afi ye the treatment no a ye friend no stretch therapy e dey correct spine no. And pain be brain na ya na ye scan the first na ye hu problem na ye treatment no for a while na ya science so assign scan ni biem edani green say ya na say na chi no eyo okay wo hwe wachi nkase na aha eyo ukon na ukon no e connect nerves na ewo mu no eno na ba wo trim wanim obi wo ho no ma oti ho a o se me nan agene ana se menti na che se dompe mienu na edi so wa ha no eno na eho aka etimi chia eco left say etimi chia e dey call right say etimi chia so dey ba left se echia sa na eka amia nerves no na ama onan no ayetitiri obi wo ho no mo a ade ba ko oye ne se oti se ne chie ne yape na ode ointment e dey asrasra ho na adwen ye ne se we beko ointment wo dey asrasa be ya afini ekwa afimi enu ni e beko anke kodadaada bra mayen twa scan na yen hwe wachi nkasa ne ma near straight which in the mount, now I'm not top precope because so one straight in nearby and say a coswa cha na a fede a be wiki cry na ultimate and only a friend nerve compression and as a nerve root compression a mat and conformably and they are a pew chamber. A higher food supplement will hold. Yes, some we are real now ye to a sea cry at the amount.
My Yarisa, and I mean, my dear me. No, I'm a chido, penny, me calling, I am here. Timmy, the Ananti hospitals, sir, me quite a mammy in Rosa bite. No man, I paint in a samba. Yet, see your woman, Cassine, and I'm in Dana. Timmy, buy a machine, so it's netting, don't be mamma. Pray, pay, and who send me here.
When your pains all my chica crack, baby, swimming, send a Germany. Now, my co hospitals be brave. Me call mommy Joe, and yeah, dear, my noon donor as a still. It was a chemistry as a Kodakram parliament to me and Daname. Intimini will be in Como, and now Odi Spine Center, whom I don't say chairman. In fact, Machina Yemia, Senator Yemin, in TBBM.
What could X-ray? Doctor Sobayo surgery, men soup, men money how, men Tinaho in Yarrow, Odia Fabra, for X-ray Nebra, Nayan Shenina, Yacha will be a better Nina, Kama Mount. There were branches in Yenu, Ewa Akraha, Spinters, and North Carnation. Just say if I don't be one dear Fabra, na yen treat in mouth. Na bibia enye kama memfa painkillers enye weduane anopa wafa ewia wafa enyimre wafa anadwo be dance wasan afa me pacho kidney problem na wo pe ede ama wo in fact yen pe ene yakofa spinal scan etimi detect spinal misalignment bia wo wachi there was physiotherapy wo ho there was stretch therapy there was gym there was massage. In fact, so we are no uba. That's a was say a here referrals. Cry your referral systems. A year juma wa hapa papa. A bet me a referral. Sa Ghana ha sa manoni na wakotria wa yare sana so. Inti menstrual cry. Dear bra. Ye tie bia no ye beshe dear mom.
When you get there are so many things that you can buy, including the book that Dr. Labi have written. Very simple. Very simple and understanding your spine, the way it works, and it will give you the biggest picture of your life.
I had a problem with my waist. I was virtually stiff down. Virtually, I could not move. After going through some treatment with the Spine Therapeutic Center, I am fine. I feel much better, I'm stronger, and I can walk. Now I can even give some action and joy to my wife. Spine Therapeutic Center, your spine is our concern. In fact, Ghana ha abasomodi a dia boy no edoso pa titwa na mo na bra da bia wo firi bia wo ba wo benya ka e wo circle ana se condition wo de wo duru circle ana condition a wo se wo person le ka wo fa ka na wo so be si wo last stop wo si ya ye clinic na e wo ho.
In this house any longer. The house is accordingly informed, unquote. These are words that affect the rights of these MPs to remain in Parliament and the rights of their constituents to their representation. Thus, if a controversy is raised to the propriety of the interpretation of Article 97(1)(g) that led to this conclusion, then this court is rightly sized with jurisdiction to provide a hearing. According to the plaintiff, the Speaker's interpretation of Article 97(1)(g) was wrong because he, the plaintiff, also interpreted Article 97(1)(g) as affecting members of Parliament who wanted to change party affiliation. He also interpreted it as affecting the status of parliamentarians in the next Parliament and not while sitting in the 8th Parliament. These and others are the disputed interpretations that the plaintiff presented to the Supreme Court to give the nation the correct meaning of. For the sake of the record, we set out Article 97. 97(1). A member of Parliament shall vacate his seat in Parliament upon a dissolution of Parliament, or if he is elected as Speaker of Parliament, or if he is absent without permission in writing of the Speaker and he is unable to offer a reasonable explanation to the Parliamentary Committee on Privileges from 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet. Or D, if it's expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution. Or F, if he resigns from office as a member of Parliament by writing under his hand, address to the Speaker. Or G, he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party. 2. Notwithstanding paragraph G of clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original or political party forms part shall not affect the status of any member of Parliament. Now clearly, with the disputed interpretations alleged in the plaintiff's statement of case, even if the parties had gone to the High Court under Article 99, the High Court would have been compelled by Article 132, as happened in the case of ex-parte Zaneto Rawlings, to refer these contested meanings to the Supreme Court to determine the correct interpretation. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seat of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself. We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes of the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. Exercise of discretion. The Speaker of Parliament is urging that the Supreme Court breach the rules of natural justice and rules prescribing the manner for exercising discretion in the orders made on 18th October 2024, in hearing the application ex parte and granting orders to stay execution of the Speaker's ruling pending the resolution of the suit. It is a very basic and primary principle of law that an order of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament? What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The four constituencies of Amenfi Central, Formina, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker. The Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the four people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance, arising from the outcome of the ruling, weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the four members of Parliament is the current second deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved. The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit. The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day. But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay enforcement of the Speaker's interpretation of Article 97(1)(g). Grant of orders beyond 10 days. The Speaker's lawyer urges that because of Order 25 Rule 18 of the High Court Civil Procedure Rules 2004, CI 47, that enjoins high courts to grant injunctions and other preservation orders for 10 days in the first instance if heard ex parte, and without notice to one party summoned before the court. The Supreme Court was also enjoined to grant the ex parte order for 10 days as a matter of rules and practice. This is a submission that fails to appreciate the import of Article 2.2 and 2.3 and 2.4, which guide the Supreme Court when dealing with a constitutional matter such as this. We will quote again Articles 2.2, 2.3, and 2.4. The Supreme Court shall, for the purposes of a declaration under clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to declarations so made. Any person or group of persons to whom an order or direction